This is Colin O'Keefe back for another episode of LXBN TV. Joining me today is Daniel Schwartz, attorney at Pullman and Comley and author of the always insightful Connecticut Employment Law Blog. Today we're discussing a subject that's always popular with everyone, and that's social media policies for employees. You know, starting with the basics, Dan, what are the essential parts of a social media policy? I know just don't be dumb isn't quite enough for many people.
Yeah, I've tried to encourage employers to just tell employees to use their best judgment, but that doesn't seem to be flying anymore. And we keep seeing examples of employees whose best judgment isn't really judgment at all. So I think for employers, the key question in shaping a policy is how much trust you want to place in your employees. You allow certain employees to talk with the media. How much do you want the employees to talk about without you knowing about it? So that's one real important question to ask. The second is, in shaping your policy, do you want it to be a list of things that the employees can't do? Or do you want to be a little bit more encouraging and talk about the ways employees should be using social media? And that may be, don't talk about things that you wouldn't want to see on the cover of the New York Times. But it can also be, be positive, interact with the thought leaders, add value. If you make a mistake, correct it. So you can really structure policies in a lot of different ways. I think the other thing to think about as they're thinking about policies is to not lose sight of the fact that the employee's performance still matters. At the end of the day, regardless of whether they're using social media, you don't have to regulate social media so much as it is regulating the employee's performance. If they're not getting the job done, it doesn't really matter that it's because of Facebook. It's that they're not getting their job done. So don't throw out everything that we've learned to date just because of online. You can still apply the same rules. You just have to be a little bit smarter about it.
Definitely. And then moving on from that, we've obviously seen, on your blog and other labor and employment publications, the National Labor Relations Board come down, not necessarily come down hard on companies, but they definitely will police companies for disciplining employees for social media activity, and they'll get upset if you're, firing your employees for certain activities on social media. So what can employers discipline their employees for, and then what can't they discipline their employees for as far as social media goes?
Well, I think that the employers need to realize that their firewalls that they used to just prevent employees from accessing Facebook don't work anymore. The reason why is one of these. The iPhones, the smartphones. Everyone has one. And if they don't have one yet, they're probably getting it for the holidays. So employers need to recognize that you need to provide the guidelines, first of all. And in terms of what they can do and not do, you need to realize that employees can talk about work and still be protected. There's this concept and notion called protected concerted activities. And I think the simplest explanation is when employees are talking about the terms and conditions of their workplace, the NLRB has said that limited area is protected. It doesn't cover when employees are swearing about customers. It doesn't cover when they divulge confidential information. But the same sort of talk that employees used to do on smoking breaks, or they used to talk about on water cooler breaks, that's the type of thing that employers shouldn't overreact for. I've been talking with a lot of employers, and just because you see a Facebook post, doesn't mean you understand the whole context of it. What were the communications both before and afterwards? Is this the way that the employees talk, sort of in this text shorthand of the LMFAO? It can be a little bit profane, but right now it's also the name of the music group. So let's not overreact on everything that comes across. Not every Facebook post is a fireable or firing-worthy event.
Definitely. And then in the case with some of these bigger companies, the backlash that comes out over these types of things can be worse than the initial post itself. So
that's exactly right. You had this employee who posted a song on Starbucks about Starbucks on YouTube, and all of a sudden, he's a internet sensation because he was fired. So you got to be careful and pick and choose your fights.
Definitely, definitely. And lastly, you're obviously someone who's used social media to their advantage and built up a reputation through that. How do employers balance the potential risk that they see with the opportunity for their employees to bring in more work for their company? How do they balance that in their social media policy?
I think businesses are used to taking risks. That's what business is. That's how entrepreneurs succeed. They look at the risk, but they also balance it with the positives that come about as well. Social media does have risk because you're losing control of your message. You're losing control of the communication. That is the inherent risk in social media, and there's virtually nothing that you can do to contain that entirely. You can control it to some extent. You can be part of that message, but you're never going to fully contain it. Mm-hmm. So I think businesses need to understand that in engaging in social media, you're going to give up a level of control, but in doing so, you're part of the communication. I tell people who aren't on social media, people are already talking about you. You just don't know it. Mm-hmm. So with social media and being involved with social media, you have an opportunity to engage your customers, to engage clients, and to engage employees. There are many employers who are using it as a very good recruiting tool. Mm-hmm. And they're finding the employees who are using social media to be those who are using technology proficiently, who understand the risks of social media, but who may be quite bright and adept at it. So, it's the old expression, don't throw the baby out with the bathwater. Still applies in modern times. Just because you've seen a few examples of social media, there are 800 million people using Facebook today, and not all of them are kids posting what they had for breakfast.
Yep, exactly. And it's just, it's a new technology, but ultimately it's just another means of communication, and the ways that you police it should ultimately remain similar to how they've been in the past.
Yeah, and look, we are where we were with email 20 years ago. When email first came out, the idea that you would have client communications with people via email was foreign. That'll never replace a letter.
Yeah.
Well, letter writing is becoming a lost art. And social media is taking its place soon. So you can adapt, or you can be left behind, I think, with social media, because it's not going away anytime soon.
Mm-hmm. Definitely. Well, once again, that's Daniel Schwartz of the Connecticut Employment Law Blog. For more insight on social media policies and their best practices, be sure to check out, of course, ctemploymentlawblog.com and lxbn.lexblog.com. Thanks, Dan.
Thanks, Colin.